What is going on, everybody? It's Mark Real Jr., the Father's Rights Attorney, and we're going live across all of our platforms today. So whether you're watching it on YouTube, Instagram, whether you're watching it on the Real Father's Rights channels, or you are watching it on my Father's Rights Attorney channels, thank you for hopping in and joining us today. Today, what we want to do is with this webinar is all about giving out information, and we are going to cover anything and everything that is Southern California divorce. So we're going to go over the framework, the timing you can expect, what exactly you are going to see, going to deal with, and going through the process. Cool thing about what we got going on here is we got people across about 15 different channels and platforms that are going to be watching. If you comment, I'm able to see your comment regardless of platform on here. So feel free to ask questions as we go on, as we cover the material. So I got Jeremy in the background here. Jeremy, can you go ahead and put the QR code up on the screen before we hop in? So Jeremy's going to there's going to be a QR code. Audio is very static. Looks like coming from YouTube. Is that better now? Are we hearing the audio a little bit better now? I was kind of a little bit away from the microphone. All right, so Wayfangle 69, is the audio better? Can you hear better when I'm like this? I want to make sure we got solid audio here. All right, no. Jeremy, can you check on the audio on the platforms in your headphones here? All right, we're gonna check on this audio here. Make sure we got it. We'll get the QR code up here. If you are in Southern California and you want to talk to someone on my team about your divorce and maybe how we can help, scan the QR code. You can schedule a free case evaluation. And Jeremy, what I'm going to actually do is I'm going to switch over to the other microphone here. All right. So excuse me, guys. I'm gonna flip over to. Hopefully that helps. All right. Are we better now on the audio? Jeremy's giving me the thumbs up on the back end that we're better on the audio now. All right, awesome. So hopefully you guys can hear me now. We're good to go. Feel free to keep dropping questions in the comments, whatever platform you are on, and whether it's myself or Jeremy may read them off from behind the camera here. So we can go ahead and drop the QR code, Jeremy, and we can hop right in. All right. So, as I said, my name is Mark Real Jr. I am a California licensed family law attorney. On the internet, many of you may have seen some of my stuff, the Father's Rights Attorney. Here at Real Father's Rights, we focus exclusively on representing men and fathers in California family courts. Those of you watching in other states, you may find some valuable information, but I want to be clear, I'm licensed in California. The specifics I'm going to talk about today are specific to the state of California. So today is going to be all about divorce. We've done these on custody before. We've done these on domestic violence. This is going to be the first time we have done something like this specific to divorce. So my goal and objective today is over the next about 20 minutes to go through every step and what you can expect in divorce. And as we go through it, as questions come up, feel free to ask them. We'll stop and answer them. And then at the end, we're going to open it up again for a full Q&A on anything and everything. So during the presentation, let's try to keep it topical. At the end, hopefully we'll have 15, 20 minutes where I can just answer your questions. All right. So the components of a divorce. So there's 4 or 5 components to every single divorce. Whether you want to split out child support from child custody. So it's ending the marriage, it's child custody and support, it's the division of property, and spousal support. So those are the main components that are part of every single divorce. And if we're able to settle those issues, if we're able to come to conclusions on those issues, whether it be through negotiation and coming to an agreement or through trial, that's how we're going to be able to finalize a divorce. So, end of a marriage. That is very self-explanatory. I will say one of the pitfalls, one of the things that I always tell men they need to be aware of is something in the state of California. California is one of 9 states that's what's called a community property state. And a date you put on your petition or response could end up creating quite a bit of harm financially for you. And that is your date of separation. Date of separation is a big deal in California marriages. I've seen a ton of cases go to trial specifically on when the date of separation was, whether a piece of property was purchased, whether a business was started. There's a lot that can be determined by that date of separation, because date of marriage is pretty easy. That's the date you got married. That's on the marriage certificate. Very rarely is that disputed, but date of separation can be a big, big deal. And another piece about the end of marriage is you don't have to resolve all of these issues to become officially and finally divorced. There's a process called taking status where we can do, the legal term is bifurcate your marital status from the other issues once certain benchmarks are hit, where we can bifurcate and you can become a single person while there's still divorce proceedings going on. We see this a lot in situations, whether it's good or bad. A divorce maybe is drug on and someone wants to get married again, or for tax purposes. There's different things that happen, but that is something that's possible during the divorce process. The next piece, child custody and support. So for a lot of our clients, this is the biggest deal. And this is really why we exist as a firm, the division of custodial time. And we can dive in a little bit later into some specifics, and maybe some of you have some specific questions. But typically when it comes to custody, when it comes to a divorce, this is the most long and drawn out part of the process. Is you're probably going to go get a temporary order right away. That temporary order may change and evolve over time. And then ultimately you get a judgment, which is kind of your final custody order, which means there are now additional burdens that must be overcome for that to be modified. And really what goes hand in hand with division of custodial time is the calculation of child support. In California, we are an income share state. So the very short of how child support is calculated, it's going to take both parents' gross income. It's going to take the division of custodial time. And there's some other things, some minor adjustments, exceptions that can be put in there. But basically, you're going to take the income both parents make and plug the custodial time in as well. And it's going to spit out a number. And the way the California formula is written, and a lot of states are this way, is the income share. So they want to try to make the households as equal as possible based on the custodial time. So what that means is in the state of California, 50-50 custody most of the time doesn't mean there will be no child support. A lot of times there still will be child support. And I've even seen cases where the custody is 55-45 or somewhere in that range. And by the calculation, the parent who has less custodial time technically would be receiving child support, or the parent who has more time be the one paying for child support. So that's very much possible in the state of California. So the next piece, it can be a big part of your divorce. It can be a non-existent part of your divorce, depending on where you're at financially, but the division of property. In California, we are, I'm static again. We may be having some Wi-Fi issues. Jeremy, can you check on that? We're checking here. We switched mics up. So am I still static? I'm staticky. All right, let's see. We're gonna get to work on that real quick. Sorry about this, guys. Still static? All right. Yeah, it looks like we may be having a little bit of a Wi-Fi issue. We're good now? We're good. All right. So we changed up the settings again. Are we good on static, everybody? Some comments here on the child support, or we can agree on a lower amount. Yes, you can. Many times. I still remember I had a case where I think it ended up being a 52-48 custody split, and the dad was the one with 48%, but he was on disability, and mom would actually owe him child support. He's like, I don't think that's right, and he went and waived it. Also, you can come to an unofficial agreement. You can say, hey, $500 is enough and not worry about the calculation. So that is something that can happen. If it's being done through your divorce, if Department of Child Support Services is involved, a little bit of a different story. And then in regards to child support, can my ex go after VA disability? VA disability is a very unique topic when it comes to divorce. So that's something we could probably do a full hour on. So there are certain situations where it does apply, and there are certain situations where it does not apply. And I know there's I've seen a lot on the internet, there's the misconception that your VA disability doesn't apply for anything and it doesn't apply in regards to child support. That's not true. It is still considered income. It's treated a little bit differently. I mentioned the general calculation is parents' gross income, custody split, spit out a number. VA disability, union dues, there's some different things where different factors come into play. All right, so we'll hop back in here too, I see some other questions coming in. We can hit on bifurcation a little towards the end here. So division of property is not just a house. Usually the house is the biggest bone of contention. Let's just be honest. Here in California, with home prices, most families, the vast majority of their net worth is tied up in their home. So usually that's an asset that is so large that it can't be divided, or one side is not able to refinance exclusively under their name. So that's usually a big component of the division of property, but this is bank accounts, investment accounts, this is retirement accounts, and there are some unique assets as well. I mean, I've seen situations where fine china worth thousands of dollars, or you have a lot of electronics, or guys, if you have toys, if you have dirt bikes or sand toys or boats, those are all part of the division of property, even if she's never used them, if they were purchased during the marriage. And this is where I told you earlier the date of separation is a big deal. California is what we call a community property state. It's one of 9, I believe, that are community property states. And what that means is from the date of marriage until the date of separation, unless you have a pre or post nup, everything earned or lost, so all income, assets, appreciation, debt, all of that occurred during the marriage is considered jointly yours and jointly hers. Without a prenup or postnup, it's 50-50. So if you went out and bought a $200,000 boat during the marriage and she was on it twice but used it every weekend, it was purchased during the marriage, it's going to be presumed to be community property and have to be divided upon divorce. What if my ex-wife keeps changing the date of separation throughout litigation? All right, so we see this all the time. A lot of times what will happen is that date of separation is a little gray. There's not an individual date where one of you walked out of the house or went and slept in the other bedroom and there was a clean division or separation. So we see this a lot, and then quite frankly, I think there are some times where attorneys get into a case and they see you started a business, you went out and made a financial move, and it would be advantageous to move that date. Some of the most contentious and high-stakes litigation I've ever been involved in revolved around date of separation. I had a case where the couple had actually filed for divorce several years earlier and then reconciled, but the divorce case was still open. And typically date of filing is kind of our backstop on date of separation, like once you file. But this couple reconciled, and actually the wife had started a business, had purchased property with someone else. There were a couple different things, and they wanted to argue that the date of separation was the date of filing, despite the fact that after that date, these two had moved back in together, had held themselves out as husband and wife. So that's something that happens, and I always go back to this in family court. Family court is a credibility contest. So if you're constantly amending or changing something or changing your position, it's not going to look good in front of the judge. So if she keeps changing this date, and she's done that 2 or 3 times, but you're steadfast on a date, understand that when it comes to that issue, if that issue goes to trial or you go to mandatory mediation, that judge or that retired judge in a mandatory mediation may look at the other side and say, like, there's no way you can win on this issue because they're 100% certain and you're not. So it's going to come back to a credibility contest. Like I said, unfortunately, a lot of times date of separation can be very, very, very high stakes when it comes to money in a divorce. And so it's an issue that's pretty heavily litigated. It also, we're going to talk about spousal support. It also comes into play there. And we'll kind of transition now. We will transition into spousal support, because a lot of times date of separation, the first issue we usually see with date of separation is trying to jockey and maneuver it so it financially benefits. Maybe a business was started or a purchase was made or an increase in value in stock, whatever it may be. The second one is for purposes of spousal support. So spousal support for most counties, there are a couple outlier counties that use the calculator. There is about a 10-factor test of things the judge will look into in terms of making a spousal support order. Most divorce cases, you're going to have 2 orders made in regards to spousal support. The first one is going to be a temporary calculation. That's something that usually happens very, very early in a case. One party requests spousal support and they make a temporary order. The second is the permanent calculation, which either comes in the form of a marital settlement agreement or a judgment after trial. So one of those 2 things. When it comes to spousal support, there are 2 pieces that are very, very important to understand. And that's the difference between a short-term marriage and a long-term marriage. So a short-term marriage, generally in the state of California, it's presumed to be a short-term marriage if you were married for less than 10 years. And this is really important for spousal support because long-term then is 10 plus years. If your marriage is deemed a short-term marriage, the presumption is your spousal support order will be for half the length of the marriage. So half the length of the marriage is typically what you're going to see. So if you were married for 5 years, that would be 2.5 years or 30 months of spousal support. Now, if you were in a long-term marriage, they will typically order, unless it's agreed upon by the parties, they will make a spousal support order that is indefinite. And if you want it to change, if you go to retire, you'll actually have to go back to court and get a new order. So if your marriage was a long-term marriage, they typically won't put an end date on that spousal support payment. So, for example, I've had situations where someone was married for 20 years and now they've been divorced for 20 years and they are going into retirement and they have to go back into the court and petition for spousal support to be reduced or eliminated because they're like, hey, I'm retiring now, I'm no longer able to earn that income, which being of retirement age and pursuing that is a valid reason to reduce or eliminate spousal support. So that's a big one. But I will say it's not 100% ironclad that sub 10 years is short term. My partner Ryan tells a story of he had a marriage that lasted about 9.5 years and was actually able to get the judge to grant or order that the marriage should be considered a long-term marriage. And there are a couple other little factors, but in general, that's not typically an overly litigated area of a divorce. Jeremy, you want to go ahead and put the QR code up on the screen here for a second? So let me get a drink. So Jeremy's going to throw QR code up on the screen. If you are looking to talk to someone about your divorce, maybe what's going on or what maybe to look into the future, scan this QR code and you can schedule a free case evaluation with my team where we can talk over what you got going on and see how we can help you. All right, we can go ahead and take it off. Looks like that may have only went up on the Instagram feed, but... All right, so now, Justin, are you able to assist with situations outside of California? No, I am not able to directly assist with situations outside of California, but if you, it looks like you're on YouTube, if you comment your location, I can have the team see if we have any referral partners or people we would recommend in your area. And we have quite a few people throughout the country. So if you want to drop where you're at, we can take a look at that and get you a message. Probably be easiest, YouTube, we can't privately message you. If you go to the Real Fathers Rights Facebook page or Instagram and send us a DM, we'll be able to get back to you and answer any questions. All right, so we'll move on here. The steps of divorce. So I want to go through and I want to set expectations in terms of what you're going to deal with and what you need to understand. So the first thing is, I'll tell you as we get into kind of the steps and the timing here in California, is that no one could predict exactly when your divorce is going to end. Justin, thank you for the message. Jeremy will get back to you here today on if we have anyone that can help you. So I will tell you from our data, the average divorce that we handle typically takes 18 to 20 months. Now, we have divorces that take less than 3 months. We also have litigation that's been ongoing for 4 or 5 years. So there's a pretty wide range. But there's the same basic framework when it comes to the steps and what to expect. So the first thing is a petition. Now, I'm guessing it's probably mostly men watching this, and given that probably 2 to 3 out of every 10 divorces is actually filed by the man, so the woman is actually filing the vast majority of these petitions. That's a petition for dissolution. Dissolution is the fancy legal term we use for divorce. And that basically gives the basic information and opens the case and tells the court that this party wants a divorce. Once the petition has been filed, they must personally serve the respondent. And it must be someone over the age of 18, and it can't be them. So they can't walk in the house and hand you the divorce petition. That's not sufficient service. But unfortunately, I've seen everything from the new boyfriend to the in-laws to an 18-year-old child of the couples serve divorce petitions. From a professional standpoint, we usually like to have a process server do it just to kind of button everything up. But anyone not the party over the age of 18 serves the person that has now become the respondent in this divorce. Once you are served, this is very important, and a mistake a lot of men make is that you have 30 days So you have 30 days to respond to the petition. If you don't respond to the petition within 30 days, they can actually file for a default and essentially get anything and everything they want. So a lot of times we can undo a default, but honestly, it's an expensive and unnecessary process. So you need to get your response within 30 days. I'll tell you, if you hire us and we're really close to the deadline or past the deadline, a lot of times we'll be able to call up the other attorney and say, hey, we're on the case. Give us a few days to get the response out. And they'll be okay with that because we can unwind the default. It just takes time and money. So that's a big one is, guys, I'll be honest, y'all wait till the last second. You need to take action on this because you only have 30 days or there could be some catastrophic problems for you in the future if you don't. So typically 3 and 4 are a lot of times interchangeable. A lot of times an RFO, request for order, is filed with the petition and with the response. But there are kind of two things. The first one is PDDs, or preliminary declarations of disclosure. So California is what we call a full disclosure state, which means both parties must fully disclose all of their financial holdings. Businesses, retirement accounts, anything and everything, investments. So we're not talking about just what you have in the bank. We're talking about everything down to furnishings in the home, minority business holdings as a limited partner. All financial holdings must be disclosed by both parties. And that's supposed to happen within about the first 60 days after a response is filed. Quite frankly, a lot of times that process drags on a little bit because it's not something that's super, super time sensitive, but the family code says it should be done in that first 60 days. And this is designed to create a situation where there are no financial surprises. The biggest surprise usually with PDDs is the husband or wife has a credit card the other side didn't know about, and it has $25,000 on it right now. So, and a lot of times that'll be considered community debt. So we want to prevent those. RFOs, this is usually, candidly, early in the process, what's usually most important to people. This is everything from requesting a child custody order to requesting child and spousal support. A lot of times, one side may request to kick the other side out of their house. Unless you have good cause, the judge is usually not going to grant it. Fun fact, most judges in California aren't going to do anything about you living with a person who you hate their guts for a year while you figure this divorce out. So you can't just ask for them to get kicked out of the house and the judge grant it. Usually you have to give them good cause. But the major one is getting a child custody order, especially if the parents have decided to live in separate homes. One of the worst parts about this process early on when it comes to the child custody is if you're still living in the same house and you request a child custody order, a lot of times the mediators, they won't make a recommendation because you're still living in the same house, and therefore the judges won't make an order. So kind of one of those chicken or the egg situations where we want a custody order because we want to move out and live separately, but you won't give us one until we actually do, and then we have to wait 90 to 120 days from filing before you actually give us an order. So typically, RFOs, I've seen RFOs timing-wise, it's from date of filing. Riverside, San Bernardino, typically 60 to 90 days. San Diego's typically a little bit further out, maybe 120, 150 days. Really depends on the department, the judge you're in front of. But San Diego uses ex parte filing, so those emergency filings a little more liberally. So you can typically, if you really want to, even if it's not an emergency, get in front of a judge within a couple of days. But then there are other counties where I've seen it's 30 to 40 days, some of the smaller, less populous counties in maybe central California, where things move a little bit quicker. So once we get through that process, and typically there'll be multiple RFOs for multiple issues that happen as you work your way through the divorce process. As we get to that point and it's clear the parties aren't going to agree, we'll talk kind of about the end of it. if you hit the gas pedal on your divorce and we know it's not going to settle, like we identify a case early in the process and we're like, there's no way this case is going to settle, you're typically looking at a year and a half to 2.5 years before you can get trial dates. If custody's involved, a lot of times they're going to want a custody evaluation by a professional, a therapist. And then there's usually bickering and fighting and kind of figuring out where everything is financially. So from petition to trial, depending on the judge, a year and a half. Sometimes it can be a little bit shorter if it's maybe one narrow issue, but you're going to look at a several-year process if this thing's going to trial. When you get ready for trial, so one of the last things that gets done, each county has their own processes, disclosing evidence, witness lists, all that stuff, but you're going to have to essentially redo your PDs. So you're going to have to do your final declarations of disclosure, your FDDs. Those are going to be required. Usually the judge sets a deadline a couple months out from trial where you make those final declarations in regards to your finances. And then heading to trial or judgment. I've seen final trials on divorce last anywhere from 2 hours to 4 weeks. It really varies. The more issues you can resolve, the shorter that process, because, I mean, to be honest with you, a month-long trial is probably a six-figure endeavor, where if we can get it down to a couple hours, it may only cost you $5,000 or $6,000 for that trial. So the length of that trial is usually going to be dependent on the number of issues that are still out in this case, whether, hey, we're just doing date of separation, or we have custody, we have child support, we have spousal support, we have different property issues. Property issues a lot of times are ones that can be very time consuming. You get a business valuation, or there's some dispute over the home or when the home was purchased or how the home was purchased that gets really technical with experts. That's usually where it becomes time consuming. So typically you're looking, if you go all the way through this process and you go to a trial, you're looking at a year and a half to 2.5 years, sometimes longer. I would say that the average time ballpark to a completion of a divorce for individuals that work with us here at RFR, that is typically somewhere in between a year to 18 months. So usually during that time, we're able to work through most issues. The vast majority of divorces, whether it be for financial reasons, physical, mental, emotional exhaustion reasons, do end in settlement. A lot of times the judges will kind of let you know where they stand and what the likely outcome is, and it usually makes financial sense for the parties to have a meeting of the minds and come to an agreement and draft out their own marital settlement agreement rather than the judge making an order based on trial. Jeremy, you want to go ahead and drop the phone number? We do have, we got the QR code. We can put the QR code up there too. If you are in Southern California and you want to talk to my team about your divorce, your custody situation, domestic violence allegations, anything like that, you can scan the QR code. Jeremy's also going to drop a phone number in the chat that you can give us a call and schedule that case evaluation. We have appointments available as early as today or tomorrow, or all the way through the weekend. We do case evaluations 7 days a week, so we're here to help. All right, so I want to move into specifically here talking about some of kind of the pitfalls of the different parts of a divorce, or the mistakes we see made. So, as I said earlier, 70 to 80% of divorces are filed by the woman, and the man is the one that served as the respondent. So, vast majority of divorces are started by the woman. And so we don't see a whole lot of issues in regards to petitions, but a big mistake that costs guys a lot of money, and I'm going to keep harping on this, is once you're properly served with a petition, you have 30 days to respond. Now, I do want to point out that even if you are not properly served, if she hands you the paperwork, if she has your 16-year-old hand you the paperwork, she mails it to you, you still need to be responsive to it and at least acknowledge it and go get legal counsel on what needs to be done. Because to be honest with you, fighting over proper service of a petition a lot of times doesn't make sense. There's really no benefit. It's just an additional expense. So even if she walks in the door and hands it to you and you have not talked to an attorney, you have not sought out legal counsel, I would say you need to go do that. Because even if service was improper, we may be able to leverage that for you, but we also don't want to go through the expense of her continuing through the process after that's improper and us needing to unwind it. So when it comes to the petition and response, the biggest thing is timeliness. And whether it's custody, whether it's a divorce, whether it's domestic violence, I would honestly say the biggest mistake I see men make is they wait until the last second, or they wait until there's where there's very little time to prep or prepare before they really acknowledge it. I know it's not a comfortable situation. I know it's not ideal, but we really need to focus on taking these things head on. All right, so preliminary declarations of disclosure. This is the one area of a divorce that men spend more money unnecessarily than any other area. So depending on how complex your finances are, your PDDs may be very short if it's just a couple bank accounts, a couple vehicles, a home, all the way to situations where there may be multiple investment properties or large business holdings, different things like that. But we fight this battle over and over again. Men will spend thousands upon thousands of dollars in attorney's fees for us to have to scratch and claw to get all of the information we need to them. We've tried everything. We tried AI software that helped men gather the information and get it put together, and all the way to having guys fill out the form on their own. A lot of times what ends up happening is one of our paralegals sits on the phone with a client and goes line by line and says, okay, this bank account, perfect. Send me the last couple years of statements of that bank account. And it takes hours of time that if you just gather the information, you organized it, it could be a quick and painless process. A lot of times people, they don't want to fully disclose everything, and we end up in situations where the other side is filing an RFO to compel you to produce your PDDs, and we have to show up in court and say, hey, we've already done this, or hey, we're working on it, this is what the holdup is. And it's just unnecessary money spent. So that's me on my soapbox about PDDs. Get your stuff together, get it organized. I know one of the bigger challenges, a lot of times guys will end up out of their house and won't have access to all this stuff, and I get it. That's a different type of challenge, but we see over and over again one of those situations where men just they wait, they don't do it, and guys, I've been there, I've seen it, I work through it on a daily basis. Just be responsive. All right, request for order. So this is probably like the most high profile, like this is the part that everybody always, usually it's custody or whatever, but request for order is our fancy way of saying in California, we want the judge to make a decision. I talked about a little bit earlier, you're looking at, in smaller counties, you may be as little as 30 to 45 days out from a hearing. I once filed an RFO towards the end of kind of the COVID era, where it took them 3 months to process the RFO and another 9 months to set a hearing. That was the Lancaster Courthouse in Los Angeles County. So it was a full year from filing. This man actually filed when his ex was 3 months pregnant and didn't get a hearing until the kid was closing in on a year old. So thankfully we're out of that, and most counties kind of have it under control. Usually the 90 days is a good kind of barometer. So it may take a couple weeks to get everything filed, and depending on the judge, somewhere between 2 and 4 months. you're going to get in front of a judge to make an order. So request for order is simply us asking the court to make an order for us. Child custody is the most common, but also child support, spousal support. You can ask them to do things in regards to property, really anything and everything that may need an order. That's the way you request this issue, get in front of a judge. So there is a caveat to that. There's something some of you have probably utilized, an ex parte request on this request for order on this RFO, an ex parte RFO, where if there's threat of immediate or irreparable harm, you can ask the courts on an emergency basis to hear your issue. Now, the key with this is it actually has to be on an emergency basis. If there's not the threat of irreparable harm, technically under the family code, the judge should not even grant your ex parte request. And in some counties like Los Angeles County, if you file an ex parte and it gets denied, they don't even set an RFO. Now, Riverside and San Bernardino, they will typically set a standard hearing if they deny your ex parte. San Diego, they basically grant every single ex parte and get the attorneys into court and decide on the next steps. So, varies by county, it varies by judge. Justin here, that's very similar to what happened to me. My ex-wife filed for separation and an application to relocate the kids while she was 7 months pregnant to attempt to file ex parte and to go to Texas for birth. Yeah, and that opens like a completely another issue we could probably spend a full hour on, and that's the move away piece of it. Now that's a weird situation too, before the child is born, which you can file paternity or divorce obviously before a child is born. Fun fact, if your divorce has not been bifurcated, if you have not been deemed single and your ex has a child, that child is presumed to be yours. Just in there with a little update. The judge was denied by the judge. Yeah, I mean, move-aways are intentionally, they really focus on what's best for the child. So, yeah, sounds like, unfortunately, Justin, you've kind of dealt with that over and over again, which I think is probably all too common for everyone on here today. So, while an RFO, you get in front of the judge, and most of the time with an RFO, it's oral arguments. The attorneys or a pro se litigant just orally argues what they would like to happen. You don't have witnesses, you don't have evidence, it's just you've presented on paper what you want, you go in and argue it, and the judge makes a ruling, which is typically a temporary ruling for then when we get to trial. Because trial is where you're going to be set aside for anywhere from, I've seen 2 hours all the way to 2 weeks of a court's time. That's where you're going to have the witnesses and all the evidence and exhibits. Some things I think guys need to know about trial. Trial is inherently extremely expensive. Extremely expensive because of all the legal technicalities required for you to go to trial. We're going to have a trial setting conference. We're going to have at least one trial readiness conference. We are going to have to fully put together witness lists and exhibit lists. We're going to have to prepare evidence that may be used in rebuttal. There's a lot of technicalities, and some of you may have seen, and binders and files and volumes of documents that are required to go to trial. If you're going to trial even on a single issue, you're probably looking at $10,000 to $15,000 in just prep work before you get to trial. Then you're talking about half days or entire days of attorney time in court to litigate that out. So a lot of times you'll look at someone and I'll have to honestly tell them, hey, we're fighting over $5,000 to $10,000. Going to trial on this issue is going to be more expensive than just settling the issue. Maybe we can get them a couple $1,000s closer and clean our hands of it. Don't throw good money after bad. So that's what I have on trial here. And then the last piece is the judgment or marital settlement agreement, MSA. This document's very important, and this is a document you need to pay attention to. Most divorces end in a negotiated marital settlement agreement. You need to be really, really careful because the language that's in that marital settlement agreement that's the law of the land in your divorce. Whether it's custody, whether it's spousal support, whether it's anything included in there. So it's usually much better for the couples, the parties, to come to this agreement rather than having the judge rule, because the judge is maybe not as abreast to what the family needs or some maybe details or specifics. But the MSA, that's the law of the land. That's the constitution of your divorce. So we'll hop in here. I know we got a few questions that have kind of been a little bit off topic here, so we will dive in and kind of hit those. So first one here from YouTube. Does my wife have the right to do my may have to rephrase this. Does my wife have the right to do my son, who is 13 years old, with my consent since she moved him out with her? Okay, you looks like, okay. So does my wife can my wife, basically we're asking about ear piercings. Ear piercings without consent. So can my wife go get my child's ears pierced without my consent? Kind of an interesting one. So, I mean, first of all these answers are going to be contingent on what exactly your court orders currently say. My initial thought on something like that would be 13 is starting to get to the age where judges are going to give some discretion. At the age of 14 in California, children have the absolute right to have their voice heard. Doesn't mean they're going to get listened to. I would say that if it's your son at 13 wants to get their ear pierced, that's not something that's unreasonable if that's what the kid wants. So does she have the right to? It'd be depending on the judgment. If it ends up in front of a judge, what would be my prediction of the likely outcome? The judge is probably going to look like, hey, if it's my son wants to get his ears pierced, it's probably going to be like, is that what the kid wants? And that wouldn't necessarily be unreasonable. Because you think about it, if you flipped it the other way and it was daughter, I know many of us have daughters that probably had their ears pierced before their first birthday. So you're probably not going to win if you fight that one. Now, if it was something more major, it may come down to being really judge dependent, because let's just be honest, some judges are very conservative, other judges are very liberal. So it may come down to your judge. If it was, hey, your 14-year-old daughter, 16-year-old daughter wants to get a full arm sleeve, and mom's like, yeah, let's do it, you may have more standing for a judge to be like, seems to be unreasonable. You can't do that until you're 18. But going and getting your ears pierced, you're probably going to lose that one. Probably not a hill that I would probably advise clients not to die on. So I hope that answered the question there. All right, so come back to the bifurcation topic. All right, so bifurcation is a general term. When it comes to a dissolution, when it comes to a divorce, we can bifurcate any topic and separate it from the rest of the case. The most common situations are this. We bifurcate the status. So until you have a judgment stating you are single, you are still considered married. So, for example, we've had a few times where guys have come in and they're scheduled to get married in a month, but they're still technically married to their soon-to-be ex-wife. And obviously you can't do that. You can only be married to one person at a time. So what we're able to do is, if everything's in order in the case and there's no adverse impact, and most of the time the parties agree, we can request to bifurcate
status. And the judge can take status and legally make the parties single. You can also bifurcate other issues. I talked about earlier about a nasty date of separation trial. That date of separation trial was actually, that issue was bifurcated from the rest of the divorce because discovery and several other issues were dependent on that decision. So we actually bifurcated the date of separation and had that trial. So bifurcation is a general term, and in a lot of situations it may make sense to bifurcate an issue. We just did a big trial where we actually bifurcated custody and had a 10-day custody trial, and the financial portion of the divorce is actually going to be moving forward early next year. So the big things about bifurcation, PDDs, all your financial stuff needs to be in order, and usually you don't want, the judge won't do it if there potentially is an adverse reaction in regards to finances or different things around the sorry, we had a little feedback there. They won't do it if there's going to say be an adverse, if there's a retirement account involved and it hasn't been joined in. So there's a couple different situations. But in general, if it makes sense, it makes more use of better use of court time, you can bifurcate any issue. Just the most common is a lot of times when there's, say, a child custody evaluation and it's going to take 6 to 9 months, or there's a business valuation, or there's experts involved in other issues, we can bifurcate status of the marriage and get you to be found single and still move forward with the other issues. So, does that answer your question on bifurcation? All right, we'll move on to the next one here. Will the separation date be affected by my spouse and continues to be financially support me and continues to do sexual activities as a couple and do things as a family? So, date of separation, I'll start with this. Typically, the backstop on date of separation is the date of filing of a divorce. So, I'll be the first person to admit, I think that there's probably a lot of sexual activity that occurs after divorce has been filed. Whether it's with new people or with the person you're getting divorced from. I think it happens. So typically the backstop or the last possible date for a date of separation would be that date of filing. Now, if you guys file for divorce, let's say she files for divorce and you guys are actively going through the divorce process, but you're still living together, still having sex, we probably, barring any other circumstances, date of separation is probably going to be the date of filing. Usually where date of separation gets messy is maybe one of you moved out or started sleeping in another room, but then maybe a couple times there were interaction, you guys were involved sexually or different things like that. Usually where the date of separation fights occur is in the gray area. So usually you can kind of backstop it with the date of filing. Now there was the one weird situation where I said they had filed several years earlier. They had actually stopped pursuing the process and moved back in and all that stuff, and that made it complicated, and ultimately the date of separation was when they restarted the divorce process under the same case number essentially. But typically, I would say the vast majority of divorces, you're really not going to get past the date of separation or the date of filing of the petition as the end of the marriage. So those things can affect, though. Financially support, I mean, that's a sticky one because, I mean, then your spousal support or trying to do those types of things. But any activities involving the two of you, typically where you're holding yourself out still as a married couple that's together, that's going to at least create a gray area. So without specific facts, without kind of a full specific situation, it's kind of going to be an it depends thing. sexual activity, financial support, continuing to do things as a couple and as a family, those are all going to impact that gray area. If all of those things are still occurring and there's been no divorce filed, you're probably not going to have a date of separation that predates that. And I'll say this, I would say the vast majority of divorces, the specific date of separation impacts spousal support, and that's about it. But there are some divorces where that date is a very big deal. So, in short, if all those activities are still occurring and no divorce has been filed, then probably not going to get a date of separation from before that. Not going to stop you from arguing it. There may be situations where it makes sense. All right, going to YouTube question here. We got, right at an hour. We'll take a couple more questions here. So, what happens to my business I built while I was married when divorcing? Does she get half of it? All right, so there are two ways to evaluate a business. We'll start here on whether a business is community property or separate property. Just had this conversation yesterday with a really successful entrepreneur. And we were actually working on some estate planning stuff. So thankfully he's not litigating. But I asked him, I'm like, hey, when did you start the business? If you started the business, and typically the easiest way to look at it is the Secretary of State, the date of filing, was the business incorporated before or after you got married? If the business was incorporated, and business is just in your name because it gets into some civil stuff if it's, say, you guys in the business together, but a business in your name, if it was filed prior to you being married, then it's considered separate property. That doesn't mean she doesn't have an interest in it, but it's considered separate property. If it was filed for after you got married, then it could be considered fully part of the marital economic community. Now, kind of the short piece of it is there are two methods for evaluating business. One's based on the market and how much the business is actually worth. The other takes into account personal effort, which your work during the marriage is considered a community property asset. So there's two different ways of evaluating it. What happens to your business in practicality? There's a few options. Number one is you buy her out. And that can be an agreed upon number. A lot of times there are experts involved and what's the valuation. I've seen situations where she wants to put a crazy valuation on it and you're like, sold, I will sell you my business for that amount of money. Because you know it's worth, because you know it's not worth that on the market. So a lot of times you'll end up coming to an agreement. She isn't going to own half of it. It's going to depend on, is it community property, separate property? If it's separate property, how much of the value was created after the date of marriage? Is there a prenup involved? So the short is she's not necessarily entitled to half. Now, if it was formed during the marriage, there's no prenup, postnup, anything like that in place, then yeah, it's a community asset and she's entitled to half of it. Most of the time, though, especially with a spouse or a partner that isn't involved in the day-to-day, you can come up with a number and buy them out. Maybe it's a percentage of profits over a period of years, or just a flat number. I've seen divorces settle with a $500,000 check and walk away and let me run my business. I think the worst thing I see happen with business owners is when these divorces get nasty and they get sloppy, they just tank their business, either intentionally or unintentionally. So if you have a business and you're going through a divorce or you think that's coming, it's really, really, really important to talk to an attorney who's experienced in dealing with, we do a lot of entrepreneurs and executives, different things here at RFR, and someone that understands whether it be stock options or executive compensation or someone who understands entrepreneurs and the reality of finances for entrepreneurs, because there are definitely people running really successful businesses and living great lives that need that next deal to go through, but their wife or their partner may not realize that. So businesses can be a complex issue. That's something you definitely want to get out in front of. But there's different, depending on what business you're in, there's different methods of evaluating it. But she may or may not be entitled to half of it. All right, I'm married for 21 years. If my wife has income of $1,100 a month, I have no income. Do I need to pay spousal support? If yes, how much? All right, so, and then we got a follow-up on that. My wife had signed the deed of trust and removed her name from the home. Is she still 50-50 part of the home? All right, so 21-year marriage, long-term marriage, $1,100 a month in income for her, zero for you. Unless there's something I'm missing or their savings or their investment, typically the higher earning spouse, which is increasingly becoming the woman, more women graduating with professional degrees, advanced degrees, just college degrees, typically the higher earning spouse is going to be the one paying spousal support. So if she's making $1,100 a month and that's your only income as a household, the theory would be is unless the court finds that you should be working and are willfully not, would be she's paying spousal support to you. So there's really, without more detail, the answer is higher earning spouse is typically the one to pay spousal support. It's not the man pays it to the woman, it's the higher earning spouse pays it to the lower earning spouse. And then on to your piece about the deed and trust. So it depends on the intentions. So just because someone's name is not on the property, seen this before. One of the spouses is a first-time home buyer in the state of California and gets a little bit of a benefit on their interest rate and their down payment percentage. So they're the only ones whose name and credit are on the house. Just because your name or her name is the only name on the deed doesn't necessarily mean that she's not entitled to a portion of it. Now, if it was done for purposes of that being your separate property and that's explicitly stated in writing, then she may not be. If this was done for strategic financial reasons, then she still may be entitled to it. So that's kind of an it depends question in regards to does she still have 50% equity in the home, or would she be entitled to a payout? It would depend on the reason as to why she signed the home over to you. So that's another issue that a lot of times they'll get kind of sloppy in court is like, what was the purpose of that transaction? Because there are some financial transactions, transfer of property, accounts, whatever it may be, to just one spouse's name that for tax benefits or financial planning purposes makes sense. That doesn't necessarily mean that you're signing away your rights to it. So, hope that helped. With that, we're at an hour and 5 minutes, so I'm about 5 minutes over here. In wrapping up, for everybody that's still on here, if you're in Southern California and whether it's you're considering, we had the questions about businesses, spousal support, child custody, moveaways. If you're dealing with any of these issues, we got a phone number that's on the bottom of the screen right now. Give us a call. We have case evaluation sessions open this afternoon, as early as this afternoon, or most definitely tomorrow, or even into the weekend if that makes more sense for your schedule. Or you can scan that QR code and you can actually book your own time. You can see what is available. So thank you guys. Thank you everybody for watching, listening. I hope you guys found this educational and helpful in some way. We'll definitely be doing more of these in the future. So good luck to everybody. If you're not, you have questions, comments, anything like that. I know we're broadcasting right now across tons of different platforms, but you can follow us on YouTube, Facebook, Instagram, TikTok, Real Fathers Rights, or you can follow me personally, The Father's Rights Attorney. That's across all of those platforms. We put out content on all of those platforms daily to help educate and help men navigate through the family court process. So, and Justin, yes, we will. Jeremy, did we get a message from Justin on Instagram? I'm gonna double check here, make sure we get you that answer, Justin. But if you aren't following one of those platforms, give us a follow. It's always much appreciated. It helps us spread the message. Justin, we do have your message. I will personally make sure we get back to you today on that. And we'll see you guys again real soon on whatever platform you're watching, or maybe you want to go to another one. We'll talk to you guys all real soon. Have a great day.